Okay, I'd like to call the Judiciary Committee back to order. Will the clerk please call the roll?
Senator Saslaw.
Here.
Senator Norman. Senator Lucas.
Here.
Senator Obenchain. Senator McDougall. Senator Stewart. Senator Stanley.
Here.
Senator Chafin. Senator Deeds. Senator Peterson. Senator Serval. Senator McClellan. Senator Boysko.
Here.
Senator Morrissey. Senator Edwards.
Here.
Mr. Chair, you have a quorum.
Thank you very much. We will return to Senate Bill 5067, which is Senator Saslaw's bill, but preliminarily, I'd like to call on Senator Vogel's substitute here, who is Senator Stanley, to deal with two similar bills, one of which he will roll into Senator Saslaw's bill. The other I think he wants to strike, and that's Senate Bill 5098 and 5099. So, Senator Stanley, as they stand in for Senator Vogel, you have the floor.
Thank you, Mr. Chairman, and I have no substitute for Senator Vogel, but I've been tasked with these bills. Yeah, thank you for agreeing, Senator McDougall. Senate Bill 5099 is a bill that Senator Vogel had filed that she has communicated to me that she would now ask that this committee strike.
It's been moved and seconded to strike Senate Bill 5099. All in favor of the motion say aye. Aye. All opposed, no. The motion carries. The Senate Bill 5099 has been stricken from the docket. Senator Stanley.
Thank you, Mr. Chairman, members of the committee. When it comes to Senate Bill 5098, she did not indicate to me, and I'm trying to figure this out from them right now, of whether it was okay to roll this bill in with Senator Saslaw's bill. So at this point in time, I guess it's a very short bill. If need be, I may make that motion to roll it in afterwards, but if we could just go forward on Senator Saslaw's bill, and then I'll consult with the patron and see what we do with that. And I just don't want to do something she didn't tell me to do, if you don't mind.
You don't want to be out of order, do you? Senator Saslaw, Senate Bill 5067. You have the floor.
Mr. Chairman, thank you. And what I want to do is move to adopt the substitute. And let me just explain, and I'll go over that. As you know, it's not a long bill. It's a page and a half, 2 pages, I guess. And what I did was I added the amendments that were both requested by the business community and by the trial lawyers. Each of them got their amendment included, and I understand with that, I've been told they're satisfied. It's a substitute that was amended. If you have it, it's 20201-033D. But anyway, what the business community wanted was the language that said, provided such person has complied with applicable and most recent federal, state, and local laws, policies, procedures, and guidance regarding COVID. They wanted that taken out. They said, in fact, they'd be better off with no bill than with that. What the trial lawyers wanted was, and that, by the way, was on line 17 at the end after herein. What the trial lawyers asked for was the following. It said, in the absence of gross negligence or willful misconduct, no person shall be liable for the failure of an individual not under control of such person. So with that, I've got in the amendments that each of that group wanted, and I would ask to move their adoption.
Mr. Chairman,
Senator,
could maybe Charles or somebody release that online, because it's not showing up on our.
Yeah, could we have this online, please?
Mr. Chair, I have released it. It's just being a little slow, so hopefully it should be there shortly.
Mr. Chair.
Senator who?
Peterson.
Peterson.
I think while we're waiting for it to come online, I just want to speak a bit, if I might, to the amendment, but also the legislation. I support this legislation. I also support the amendment. I've talked with both sides, both the business. Oh, it is. Okay. Well, I can bring my remarks to a close, but I do think the amendment makes sense. This strikes a good balance, and I hope we support the bill.
Okay. Is the amendment up? Okay,
Mr. Chair, the amendment hasn't posted now.
They said they got the
The
amendment.
substitute has been
Senator
posted, I
Duke
should
said
say.
they got it.
Mr. Chairman, it just posted.
Yeah, it's up.
okay. Charles, could you explain the amendment and how it all works?
Sure, Mr. Chairman, and I think Senator Sasslaw explained what basically the bill does. But essentially, what this is providing is that in the absence of gross negligence or willful misconduct, no person shall be liable for any civil cause of action arising from an act or omission to have resulted in the contraction or exposure to the COVID virus. And basically, the way this differs from the introduced version was the introduced version had some language regarding that there had to be certain conditions met, which was basically that the owner or whoever would be subject to this, to the defendant, had to meet certain conditions regarding laws regarding COVID, and that's been stricken out from the bill. And then the second edition is dealing with essentially third parties, and that deals with subsection C, and the amendment was in the absence of gross negligence or willful misconduct, where the introduced version did not have any mention of gross negligence or willful misconduct. It almost seemed as if there was I'll say a blanket liability protection for third parties, but this at least makes it in the absence of gross negligence or willful misconduct that no person shall be liable. So it limits it to acts of negligence, but you can still sue for gross negligence or willful misconduct if a third party does something on the premises that may result in people in other parties getting COVID.
Are there any questions to the patron or to Legislative Services?
Mr. Chairman,
Senator
Servo.
Peterson, Senator Serval.
I had a really quick question for council. I noticed on line 22, you used, I guess you wrote it, I assume, used the word individual to refer to a person who's not a corporation, I assume. And I thought the drafting convention on that, or the word term of art we tend to use in the code when we're talking about human beings, is natural person as opposed to individual. And does that need to be consistent, or?
I was not the author of this, but I think that would be a friendly amendment.
So moved.
You're adding corporation?
On line 22, striking the word individual, replacing it with natural person. Okay.
Hobie?
I move the substitute.
Second.
Oh, first of all, we have not yet adopted the substitutes. There's a, what's that? Is it a motion made and seconded to adopt the substitute? All in favor say aye. Aye. All opposed, no. Okay, now we have an amendment to the substitute. Explain the amendment again.
I want to strike the word individual on line 22 and replace it with natural person.
All right, it's been moved and Senator Deeds seconds the motion to change the word individual to natural person. Is that right? All in favor of the motion say aye. Aye. All opposed, no. Line amendment's adopted. Okay, where are we? Anybody else want to ask any questions?
Mr. Chair.
Okay, we have
Mr.
members
Chair.
of the public, I think,
Mr.
here would like
Chair.
to say a word or two. Yes, Senator McClellan.
Thank you, Mr. Chair. I have a question. I'm not sure either for the patron or for Charles. Under section B, or actually under any of this bill, if an employer does not comply with the recently adopted COVID-19 emergency standards or any similar standards that are promulgated either by the governor or the General Assembly, under this bill as written, would an employee have a remedy?
Anybody answer that question?
Mr. Chair,
Senator Peterson.
I think there's two different scenarios. One would be, is there a damage? I mean, was the employee harmed as a result of the
Yeah, I'm
omission?
sorry. Assuming the employee was harmed.
Okay, and I think I would answer to you, it would be a question of was it willful or was it gross negligence? And I'll give you an example. Under the current Department of Labor and Industry regulations, anytime you come within 6 feet of somebody in your workplace, you could potentially be violating it. So we could have just violated it during our last 15-minute recess. So it effectively would be a strict liability standard. I think if you have a situation where the employer is on notice that one of his employees is acting in a reckless fashion, they are ignoring warnings, and they do not take steps to remedy that, then they could rise to the level of gross negligence. But I think the concern was if you kept the original language in, it would essentially be strict liability. And so I think that's the short answer is they would have a remedy, but I think to show gross negligence, they'd have to show some type of notice by the employer that this was reckless conduct and not doing anything to stop it.
Follow up, Mr. Chair?
Yeah, Senator McClellan.
But if you have a case where the employer did not comply with or enforce the COVID-19 emergency standards that were adopted last month, and because the employer did not comply with those standards, an employee is harmed, would that constitute gross negligence or willful misconduct?
Well, I think I'd answer the gentlelady. Basically, again, you say the employer did not comply. I mean, the compliance deals with, are the employees keeping social distancing? Are they wearing the masks at all times? Are they washing their hands every time that they touch something? I think the difficulty with this situation and the reason for the bill is, as an employer, you really have no control over this. And so you ask whether or not the employer complied. I don't think that's the correct question. I think the question is, did the employer use a good faith basis to try and comply? Did they promulgate the rules to their employees? And if not, then I think potentially you could have a situation of gross negligence. But just to say whether or not they complied, and if they didn't comply, that they're strictly liable for anybody that gets sick, I think that's the concern of the business community. And as a small business owner, I certainly understand that concern.
Follow-up question, Mr.
Yeah,
Chairman?
Senator McClellan.
So on line 16, where it says the person shall bear the burden of proving entitlement to the immunity, does that mean that the burden would be on the employer to demonstrate compliance or reasonable efforts to comply under the scenario you just outlined, or would it be on the employee?
Senator Peterson.
I'm sorry, I had trouble understanding that question.
On line 16, where it says the person shall bear the burden of proving entitlement to the immunity provided herein, do I read that to mean that the employer would be the one that would have to bear the burden of proving that they reasonably complied with any emergency standards for COVID adopted by either through executive order or by the General Assembly?
Senator Peterson.
In other words, in this, when you just walk through what?
I think that's a good question, and I think if I'm understanding, does the word person in line 18 refer to the person who's the plaintiff or the person who's the business owner? I guess, is that your question?
Yes, basically, who would have to, you know, if an employee believes, well, the employer did not reasonably ensure that the rules were complied with.
It would be the business.
Would the employee have the burden of proving that, or would the employer have the burden of proving that they reasonably complied?
Senator Saslaw.
I would think that that's referring to the business.
Every person shall bear.
The business.
Mr. Chair, Charles, I think we could change person to defendant to make that clearer.
Yeah, I would. I think that's what Senator McClellan may be driving at, but I think that would be a helpful edit.
I so move.
Second.
Been moved and seconded that the word, what's the word, change to defendant. What's the name of the word? The individual?
Person on line 16 to change the defendant.
Change to defendant. Moved and seconded. All in favor of the motion say aye. Aye. All opposed, no.
What was it changed to?
Change to the defendant.
Take your mask off. Change the word person to defendant. You're making me not. Yeah, person to what? Oh, okay.
Change the word person to defendant.
Mr. Chairman. Mr. Chairman.
Senator Serval.
Thank you, Mr. Chairman. This bill has been very much a work in progress today, as you know, we're trying to keep the trains moving here to be as efficient as possible with our time. You know, and the flurry of amendments that have happened in the last 4 hours while we've been trying to deal with other things, whatever, I'm still concerned there's some things missing from this bill, but I'm not to anger the senator from James City County, but there's been some other action on the other side to the parallel legislation, which I think we probably ought to consider, but I don't think we ought to hold things up in order to do that. And so I think we ought to move this thing along with the understanding that there might be some changes before it hits the floor to maybe minimize the need for a conference. But just so the committee has some understanding what I'm talking about. You know, subsection B basically still just, I think, gives blanket immunity because it doesn't reference the binding COVID standards, and there needs to be some kind of a reference in there. It looks to me like the better way to reconcile that might be to put the burden of proof on the plaintiff as opposed to the defendant there, but which is what I think the compromise that I understood has been made while we were busy debating some other things has been made. So in any event, I think we need to move this along. I would move to report the bill, the substitute is amended, and perhaps we can continue the discussion as the bill is read over the next 3 or 4 days.
Okay, we have members of the public here. It's been moved, and Senator Deeds seconds the motion to report the bill, the substitute, or the bill is, I guess, substitute is amended. The members of the public ready to say whatever they want to say? I have a bunch of them here. I don't know how many were still here. Scott Johnson, Robert Melvin, Julie Dime, and the list goes on. There are a bunch of them. If anybody from the public would like to speak, you're welcome to speak now.
Rips at this point.
His references all those.
Mr. Chairman, this is Julie Dime from the Virginia Hospital and Healthcare Association, and we support the bill.
Thank you.
Mr. Chairman, Clayton Method with the Northern Virginia Chamber. We support the bill.
Thank you. Next.
Mr. Chairman, Edward Mullen with Reed Smith on behalf of a variety of clients. Really appreciate the amendment that was made, striking the language on lines 18 and 19. There might be an additional piece that does need work with the last issue that was raised, but we'll look forward to working with you going forward. Appreciate that amendment. Thank you.
Thank you. Next.
Mr. Chairman, Nicole Riley with NFIB, representing about 6,000 small business owners. We certainly appreciate Senator Saslaw including the amendment that the business community asked for this. For small business owners, having legal costs that could go from $20,000 to $50,000 just to defend yourself would be extremely burdensome for them and frankly would probably put them out of business. So we support the amendment that Senator Saslaw has put forward for us. Thank you.
Okay, thank you. Next.
Mr. Chairman, Keith Martin with Virginia Chamber of Commerce. We want to thank Senator Saslaw for bringing the bill and to indicate that we're also supportive.
Thank you very much. Next.
Mr. Chairman, Ben Trainum on behalf of the Virginia Beer Wholesalers Association. Also wanted to extend our appreciation to Senator Saslaw and all of those who have been working with us on this. We support the bill as amended, and thank you for your time.
Okay, thank you. Next.
Mr. Chair, this is Tommy Lucas with the Virginia Automobile Dealers Association, representing more than 450 franchise auto dealerships and their tens of thousands of employees statewide. We sincerely appreciate Senator Saslaw and members of the committee for working with us on this, and we are very much in support of the amended language. Thank you, Mr. Chair.
Okay, thank you. Next.
Mr. Chairman, this is Hugh Barron from the National Employment Law Project, which is a nonprofit, nonpartisan research and advocacy organization. We testify in strong opposition to the bill as amended. This corporate immunity bill would badly undermine Virginia's first in the nation COVID-19 emergency temporary standard. There are a few major problems with the substitute bill that would have serious consequences for workers' health and the public's health, most especially as amended. Corporations are provided legal immunity for getting workers and consumers sick with COVID-19. Period. Full stop. Virginia corporations will be completely immune from liability unless a worker can plead gross negligence, or willful misconduct, standards for wrongdoing that are so high no worker or consumer could ever expect to meet them. Corporations will be immune from liability even if they are flagrantly in violation of the Virginia COVID-19 Emergency Temporary Standard. The bill as amended would also undermine the Department of Labor and Industry's authority to bring enforcement proceedings in a court for violations of the Emergency Temporary Standard, and workers' ability to bring civil actions if their employer violates the whistleblower protections of the Emergency Temporary Standard. These serious consequences need to be addressed. As amended, I would urge the committee to pass by the bill for the day. Should the committee wish to move forward, it should consider the sensible amendments just adopted by the House Committee on the Courts. Delegate Sullivan's amended bill ensures that the liability standard here is tied to compliance with the COVID-19 Emergency Temporary Standard or any future permanent standard, whichever is then in effect. And it ensures that effective enforcement of the COVID-19 Emergency Temporary Standard by the Department of Labor and Industry is not undermined. As amended in this substitute, this bill is more regressive than immunity bills adopted in many conservative Republican states, and I would strongly urge the committee to reject it. Thank you.
Okay, thank you very much. Anybody else?
Mr. Chair, members of the committee, Mark Dix on behalf of the Virginia Trial Lawyers Association. We certainly appreciate the effort that Senator Saslaw has put forth here, and we appreciate the chance to work with the Chamber of Commerce and some other interests. We are opposed to the bill in its current format, the substitute, because it has stricken out the requirement that an employer do anything. That they don't, as it's worded, they don't have to comply with any guidelines or regulations or what have you in order to get the immunity. It's a free pass. So we look forward to continuing the conversation. And again, we oppose the bill. Thank you.
Okay, thank you. Next.
Mr. Chairman, members of the committee, Robert Melvin with the Virginia Restaurant, Lodging and Travel Association. And we would like to convey our support for the measure and echo the comments that were made by the Chamber, NFIB, and others.
Okay, thank you. Next.
Mr. Chairman, Dale Bennett with Virginia Trucking Association. Our industry has continued to work, delivering all the supplies and everything that we needed to survive and cope with this pandemic as we struggle with it. Civil immunity is very important. We certainly don't want to have a situation where there's a disincentive for trucking to continue to deliver what we've been doing for the citizens of the Commonwealth. We really appreciate Senator Saslaw working with us on the amendment to address the strict liability issue, and look forward to having this bill move forward so we can continue to work on it. Thank you.
Thank you. Next.
Mr. Chairman, Kyle Shree with the Virginia Agribusiness Council. We just want to echo what the representatives from the Chamber and NFIB in our support for the amended bill from Senator Saslaw. Thank you very much.
Okay. Thank you. Next. Any other members of the public? Okay. Nobody else from the public interested in saying a word or two? Okay, we have before us this bill.
Mr. Chair.
Yes, Senator Peterson?
I'm going to move to report, and if I could make a brief statement once I do that. So move to report.
Been moved twice to report and seconded. Senator Peterson?
And I'd just say this is a very short bill, but it has tremendous impact, and there were a lot of very good comments, which I respect. I also think Senator McClellan had some excellent questions, because I think we do need to tighten up the language a bit. But here's the bottom line. Right now, in order for us to have a functioning economy, we have to give people some certainty that they can open their business and not immediately get hit with lawsuits for an epidemic that's nearly impossible to trace. And I recognize there's issues of legal causation and things like that, but that's of little sustenance when you're facing a lawsuit, again, where it's almost impossible to defend yourself. I will vote to report this bill. Again, I don't think it's in its final form as we move it out right now, but we need to move it forward. And so I hope we pass the bill and take it to the floor.
Okay, anybody else have any comments?
Mr. Chair, did Senator Stanley want to roll Senator Vogel's bill into Senate Bill 5067?
Mr. Chairman, if I may address Charles's question. From what I've gotten from the representatives of the patron, this is a little different. So at this point in time, I'm not going to roll it in, but I will make just a quick presentation on her behalf, if the chairman pleases.
So the answer is no. Okay. Any further questions from anybody? Okay, you ready to vote? Okay, all in favor of the bill, vote aye. All opposed, vote no. The clerk will call the roll.
Senator Saslaw. Senator Norman. Senator Lucas.
Aye.
Senator Obenchain. Senator McDougall. Senator Stewart. Senator Stanley. Senator Chafin. Senator Deeds. Senator Peterson. Senator Serval.
Aye.
Senator McClellan. Senator Boysko.
No.
Senator Morrissey. Senator Edwards.
Aye.
10 ayes, 3 nays.
Okay, the bill passes 10-3. And maybe we'll hear more from it on the floor. Okay, so now Senator Stanley, you have one bill, Senator Vogel's Senate Bill 5098.
Yes,
what is your pleasure?
Yes, Mr. Chairman, and I can quickly do that. I do have another bill on the docket, 5079, as amended when it was brought back, but let's address Senate Bill 5098 by the patron, Senator Vogel. And actually, Senator Ruff is also signed on this bill. This is a very simple bill that basically does one thing. It creates a grant of civil immunity in the absence of gross negligence or willful misconduct to persons, corporations, et cetera, from any cause of action that's alleged to have resulted in the contraction or exposure to COVID-19 virus, and to those persons who design, manufacture, label, or distribute any personal protective equipment, PPE, in response to the COVID-19 virus.
You have to follow all the COVID
And this bill does not apply to claims of the Workers' Compensation Act, and it has an emergency clause as well. And that's the bill, Mr. Chairman.
Senator Stanley, is the difference, this is a willful violation only, is that correct?
Mr. Chairman, I'd answer you by saying yes.
Any questions of the patron? This is an unamended bill, Senate Bill 1098, Senator Vogel's bill, and Senator Ruff's bill, as explained by Senator Stanley. Any questions?
Mr. Chair.
Who's that? I can't. Senator
A question
Peterson?
for Stanley. Senator Stanley.
Yeah, go ahead.
So, Senator Stanley, this is less of a premises liability like the last one we just voted on and more of a products liability bill, because this has to do whether or not the PPE equipment that is being manufactured is manufactured correctly, as opposed to whether or not someone comes onto my ice cream shop or into my law office and contracts COVID.
Mr. Chairman, I'd answer the gentleman by saying, as far as I can tell from the reading of this bill, which I did not draft, it protects those persons who design, manufacture, label, or distribute the PPE used in the COVID-19 response. I think it's, yeah, that's basically it.
Well, further question, Mr. Chair.
Senator Peterson.
I would say it's to me that's an important nuance, because the people that are owning retail establishments, the people that just testified on the last bill, they are literally, just ordinary business people. They don't have any sort of special knowledge about COVID-19 and what happens on their premises. I mean, people come there or leave there, as opposed to people that provide PPE and design it and produce it. Theoretically, they have a specialized knowledge of this product that they're putting out into the marketplace. So it's not quite the same situation, is it?
Mr. Chairman, I answer the gentleman by certainly admitting that I'm not into that industry enough to say, but I wouldn't disagree with what he's saying. But it's not an absolute immunity. Of course, if there's gross negligence or willful misconduct, of course, then liability would attach. But it does allow for those companies, persons that manufacture, distribute PPE in the Commonwealth of Virginia, and that includes N95 respirator masks, gloves, eye protection gowns, aprons, boots, closed-toe work shoes, cleaning detergents, hand sanitizers, and cleaning products that if in fact someone is exposed to the COVID based on or while using these PPEs, that they would not, those persons who manufactured or distributed them, the PPE would not be held liable for the
Mr.
disease.
Chair.
Senator Deeds.
Yeah, I'm looking at lines 12 through 16. There's nothing in there that restricts this only to companies that exist in the Commonwealth of Virginia, is there?
No. The answer is no.
Mr. Chairman, it basically says that it pertains to individuals and corporations, partnerships, and those things in the Commonwealth, political subdivisions of the Commonwealth, or any locality or agent thereof, or any person acting on behalf of the Commonwealth, political subdivisions of the Commonwealth, or any locality in any other legal or commercial.
Mr. Chair.
Senator Peterson.
So let's say, for example, I'm a hospital system and I order a shipment of PPE and it's delivered and I give it to my employees, and despite having put on this equipment, they contract COVID anyway in a way that perhaps the warranties were not met, the equipment was not effective. Does this mean I don't have a cause of action? I can't get my money back?
Yes.
Mr. Chairman, I'd answer the gentleman by saying the best I understand of this PPE industry, which I do represent some people who are involved in it, a lot of the product is created, at least let's say the N95 masks are 3M created. There are a lot of those lots that when those lots are put together that are distributed from countries all over the world to here domestically, and then there are some that are made domestically. Same with gloves, same with everything else. A lot of the gloves that are being sold right now are made in Vietnam and are coming to the United States. I think you would have to demonstrate a willful misconduct or gross negligence on the part of the company in the manufacturing. I will say there's a lot of, in that marketplace, in the PPE marketplace, there's a lot of counterfeit goods and less than quality goods that are being transferred and sold. In that case, what you have is, unless there's gross negligence or willful misconduct, the manufacturer of the PPE would not be liable. And of course, as a lawyer, as the senator from Fairfax City knows, you would have to demonstrate that they caught the COVID because of the malfunction or the defect in the PPE.
So, Senator Stanley, this is a product liability issue, and it changes the standard to willfulness. Is that correct?
Mr. Chair.
Willful misconduct and gross negligence, Mr. Chairman, that's correct.
I think I need to highlight, though, on lines 22 to lines 24 in that subsection B, there is no mention of manufacturing
Right.
or any of the PPE. And that's pretty much exclusively in subsection C.
Right.
Subsection B does read a little bit more like Senator Saslaw's bill. And I just wanted to make the committee aware of that it doesn't seem to be the products liability concerns, but more of a general liability and premises liability.
Right,
concern.
Mr. Chairman. Servo.
Senator Servo.
Mr. Chairman, that's exactly what I was going to say, which is that subsection B seems to me to be blanket immunity for anything about COVID, about anything in the Commonwealth, pretty much. And to me, that's incredibly broad. And I didn't understand why that's even in there, first of all. But I have two other questions. First of all, I think B needs to be struck entirely. But I don't know whether to ask this to the patron, the sort of patron, or to council, but I don't understand why we're creating a new definition of person. Person's already defined in the code. I'm not clear why we're redefining person. Does anybody have an answer for me as to why we need a different definition of person in this versus anything else?
Anybody want to answer that?
Mr. Chair, I think it's because this is a Section 1 bill.
Maybe.
That raises the question, why is it a Section 1 bill?
It expires. Mr. Chairman, okay, I have additional question.
Senator Servo.
So my other question is that, and this troubles me because if you look at subsection C, the part that has to do with liability arising out of the use of such equipment, I understand that I think whoever manufactures stuff is worried that somebody could say that, you know, some manufacturer decided they want to make masks or gloves or something, and that somebody gets COVID, notwithstanding the fact they used the mask or the glove, and now they want to sue this company for making a product they hadn't made before, and we want to incentivize people to make these masks. I get that, but this also would cover a scenario, for example, say a company used some sort of a material to make a product which was toxic, and you know they injure somebody or lots of people. Say they injure a whole raft full of people in a hospital because they used materials that never should have been in contact with human skin or something. I mean, and now we're going to immunize them. This strikes me as having a lot of unintended consequences, and I'm just not clear it's really well thought out.
Would the senator yield for a question?
Me? Sure.
Mr. Chairman, would the senator yield for a question? Senator Serville, if that were the case and some individual manufactured some gloves or a mask or something that with a substance that was toxic that caused thousands of people to become ill, why wouldn't that be deemed negligent or willful misconduct that would capture that tortious act under paragraph C?
Senator Serville.
Mr. Chairman, I would think that unless this manufacturer was on notice that they were using a toxic material, it would not deem to be gross negligence or willful misconduct would have to show they knew they were going to hurt people pretty much. And gross negligence, the way the Supreme Court has operated, basically says you have to, it's almost 3 strikes and you're out. So it's almost like you used it, somebody got hurt, you used it again, somebody got hurt again, and then you still kept using it. Gross negligence is a really high bar as well. So it seems to me that if they use some toxic material and hurt every patient in the hospital, not because they contracted COVID, but because they got injured by the product, that would be out the window. So like if you created some, mask that, caused people to suffocate.
Mr. Chairman.
Senator Morrissey.
Thank you, Mr. Chairman. Mr. Chairman, I know my lane, and I'm a little bit out of it in this realm, but let me just make 2 observations. I think this bill was meant to cover the situation where an individual or a company is trying to make a buck, a quick buck, by manufacturing a flawed product, and they know it. And we've seen that situation where products have come into the country, mostly from out of the country, and it was made with inferior products because they knew there was a great demand for that product, and they did it on the cheap, and they did it to make money. Those people, I think, are caught under subsection C. I thought that Senator Peterson made a good point about what about the hospital that distributes that flawed product? I think that hospital is covered and is immune if they distribute it because they're handing out products to their employee and they did not engage in any gross negligence or willful misconduct. With those 2 observations made, I would suggest that subsection B, lines 20 through 22, should be eliminated because it seems to me that that's creating blanket immunity. If that's palatable to anybody else, then I would make that motion and look for a second.
All right, it's been moved and seconded to adopt that amendment. Any discussion? All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chairman.
Who's that?
Senator Stanley.
Senator Serville.
Stanley.
Senator Stanley.
Thank you. Mr. Chairman, quite simply, I think what we're seeing, and I've seen it representing certain people or seeing certain people in the PPE industry, is making sure we get high-quality product, but that we get product that's going to protect Virginians. And I think a lot of good corporations, and especially are going to look at certain states' liability laws before they distribute these things here. And so I think that takes care of it. We want to make sure that we have gloves, masks, respirators, eye protection, gowns, aprons, boots, closed-toe work shoes, cleaning detergents, hand sanitizers, and cleaning products available for everyone in the Commonwealth of Virginia. And so I think what this tries to protect is the supply chain of the good quality product and does not eliminate the bad actors from liability if they bring in a product that burns someone's skin automatically. at their first touching. So I'd ask that the bill pass.
Mr. Chairman, may I make a motion?
It's been moved that the bill pass. Yeah, Senator Morrissey?
Oh, I'm sorry. Did Senator Stanley just move to? Okay, I'm second.
It's been moved and seconded that the bill be, as amended, be reported. Any further discussion?
One
Mr. Chairman.
quick clinical amendment.
Senator
Since
Shorville?
subsection B has been stricken out, it would also seem that subsection E would be stricken out because it doesn't seem as if a workers' comp claim can arise from the remainder of the bill.
Mr. Chairman?
Mr. Chair,
Mr. Chairman.
Senator Deeds?
I've got a substitute motion to PBI.
Second.
Been moved and seconded that the bill be PBI'd as a substitute motion. Any discussion?
Speaking to the motion, Mr. Chairman.
Senator Serval?
Thank you, Mr. Chairman. This bill is a half thought out giveaway. Right now, the way this bill is written, some Chinese company could send us some toxic crap in a bottle. It could get spread all over hundreds of people in a hospital, burn their skin off, and nobody have any liability for it. The way this is written right now. And as somebody who's sued Chinese companies for product liability, and somebody who's discovered that basically discovered that an American judgment is completely worthless over there, it's about the last thing we need to do. And I appreciate what we're trying to do here, but I mean, many of these products that are listed here have the potential to really harm people. I mean, masks, I guess, less so, but like cleaning detergents, hand sanitizers, and cleaning products, we're going to give blanket immunity on that to anybody in the world who happens to ship that stuff or use it in the Commonwealth of Virginia. It's a poorly half-baked idea, and I understand we're trying to encourage maybe some companies in Virginia to manufacture PPE. I think a much, much, much narrower bill that maybe only dealt with like gloves or masks or something might make some sense, but the way it's written right now, to me it's incredibly dangerous for our residents, and I would support the motion to PBI.
Okay, it's been moved and seconded that the bill be passed by indefinitely. Without any further discussion, will the clerk call the roll to PBI the bill?
Senator Saslaw. Senator Norment. Senator Lucas.
Aye.
Senator Obenchain. Senator McDougall. Senator Stewart. Senator Stanley. Senator Chafin. Senator Deeds. Senator Peterson. Senator Serval. Senator McClellan. Senator Boysko. Senator Morrissey. Senator Edwards.
Aye.
Seven ayes, 5 nays, 1 abstention.
Okay, the bill is passed by indefinitely by a vote of 6-5. Okay, now going back to Senator Stanley, you want to bring back the bill that we held off from last week to today, Senate Bill 5079?
Yes, Mr. Chairman, and there is an amendment in the nature of a substitute. Actually, I drafted 2, and Charles, I think the one after much discussion on the floor is we're going to simplify this and go with the 8/24/2020 at 10:40 p.m. Amendment 202-00987D.
Would you like to explain it or have
Yes.
legislative services explain it?
I just released that. That should be available.
Okay. Mr. Chairman.
Should we move the substitute?
So move.
Okay, Senator Morrissey moves the substitute. Senator Stanley seconds the substitute. All in favor say aye.
Aye.
All opposed, no. Motion carries. Okay, now we got the substitute. What does it do?
All right, Mr. Chairman, basically this is working off my good friend, the senator from the city of Richmond, Senator Morrissey, and I had that conversation when we had the bill before, and this just simplifies what we were trying to accomplish in Senate Bill 5079, which was debated last week in this committee with regard to the law enforcement free zones, the CHOP zones that we saw in Seattle. What the bill prior to its amendment by the substitute purported to do was not only prohibit them, but also then to create an issue of liability for any civil servant, mayor, et cetera, board of supervisors who allows a law enforcement free zone to occur, and then injury results from it. This is a very simple bill now that basically defines what a law enforcement free zone is in the same description and definition that we gave it in the previous iteration of this bill. It has the exceptions for exceptional circumstances or briefly when there is a prohibition of officers going into an area because of the situation, but not because that a civil servant directed them to create the law enforcement free zone or not to go in there. This is a law enforcement free zone, and it prohibits the establishment of a law enforcement free zone by a person with the lawful authority to direct a law enforcement agency to do so. So instead of debating any more the merits of civil liability, that may be a debate for a later time, but this bill significantly makes a statement in the Commonwealth of Virginia that we as a state will not allow, will not tolerate, and will not even allow to occur any law enforcement free zones in any place in the Commonwealth of Virginia, and that's the bill, Mr. Chairman.
How do you define a law enforcement free zone?
Mr. Chairman, Mr. Chairman, members of the committee, in subsection A of the
I'm sorry,
amendment.
Mr. Chairman, just a quick point of order or something.
Senator Sherville?
I still don't have the substitute up yet, so I'm trying to read it, but
I don't either.
Trust me.
Mr. Chair, it's just being slow, but to make it easier, and Senator Stanley just described this, essentially it's the same definition of law enforcement zone in the introduced bill. And then there is a new subsection B. A new subsection B just reads, the establishment of a law enforcement free zone by a person with lawful authority to direct a law enforcement agency is prohibited. And that's the entire bill. So the definition is the exact same from the introduced version, and there's a new subsection B. I'm sorry it's taking so long, but it should be up hopefully momentarily. It just posted right now.
Mr. Chair, let me ask Senator Stanley or anybody, have we ever had anything like that in Virginia?
Mr. Chairman, I'd answer you by saying, yes, we had it attempted to be established in the city of Richmond until it was broken up by law enforcement, that they were trying to establish a zone. What usually happens in these matters is it's not that a civilian official, a mayor, a board of supervisors member says, okay, we're gonna take these 4 blocks and then we're gonna make it a zone. What usually happens is the lawlessness moves in, those that, or even just protesters moving in, and at that point they establish this zone, and then from them grabbing some geographical territory, what they do in turn is they set up a perimeter of that, and what we're trying to prevent is when that occurs, that then a civilian, anyone who has the lawful authority to direct police can't sit there and say, okay, let's create a law enforcement free zone. Let's pull law enforcement out of that area. Let's not offer the protection to those people. We've seen it also in Fredericksburg with the lady who was surrounded in her vehicle with her daughter in her car. And when the response to when she called 911, the response was, I'm sorry, we can't help you, call City Hall. Because City Hall had directed that the police would not get involved in that area. So what we're trying to do is just say, you can't have these law enforcement free zones. They can't be created by protesters or a mob or however it is, and then sanctioned by those that have the lawful authority to direct law enforcement agencies by telling the law enforcement agencies to pull back and not enforce the law.
Mr. Chair.
Senator Dietz.
I would ask Senator Stanley, in a Dillon rule state, wouldn't we have, the General Assembly, have to give localities permission before they can adopt law enforcement free zones? And aren't we then kind of backing into this situation? I mean, nobody's got authority to create one of these things right now.
Mr. Chairman,
as I understand the law.
Mr. Chairman, I'd answer the gentleman by saying no one thought these things would ever happen until we saw them a month ago. So I don't think the Dillon rule applies when a number of people then take over 6 blocks of, let's say, of Richmond or some other city in the Commonwealth of Virginia. That the Dillon rule doesn't apply, but the person that's directing law enforcement or has that lawful authority to direct law enforcement then says, well, we're going to pull back and we're going to give them those 6 blocks and we're not going to enforce the law in that area. This says you can't do that. that you have to uphold the law, you have to enforce the law, which is what we require at the state level to our local authorities, which is under the Dillon Rule, enforce the laws, protect your area. This prohibits a chop zone from occurring in Virginia.
Mr. Chair. Senator Stanley, what are the consequences if somebody thinks that's occurred?
I'm sorry, Mr. Chairman, I didn't hear you.
What are the consequences if somebody thinks that has occurred?
Well, Mr. Chairman, in the first bill that I tried, the consequences were pretty clear and provided for civil remedies for those people that had been injured and liability to the person that had the lawful authority to direct law enforcement for the injury.
No consequences.
There are no consequences in this bill. This is an up or down. Do we support CHOP zones in the Commonwealth of Virginia, or do we prohibit them?
Mr. Chair.
Mr. Chairman.
Senator McClellan.
Thank you, Mr. Chair. I have a couple of questions about Section E, which says any person who participates in a riot or an unlawful assembly in a law enforcement free zone shall be barred from bringing an action pursuant to this section. How do we define participates in?
Mr. Chairman, I'd answer the gentlelady by saying that the amendment in the nature of a substitute, which may be slow rolling out on the computer, does not have that subsection E of the original bill. Any more?
Mr. Chair, there is a technical error in the way LIS. There was, as Senator Stanley mentioned when he opened, there was 2 substitutes that were drafted. That substitute has also been posted, but the substitute you want to look at is the one that has the 0987, which does not contain any of the civil liability portions of the bill. So the other substitute you can ignore. It should be taken offline shortly. You just want to look at the 0987D substitute.
So,
Senator McClellan.
Just so I'm clear, so the substitute we should look at is the one that just ends at line 19?
That is correct, Mr. Chair.
Okay, thank you.
Senator Morrissey.
Thank you, Mr. Chair. A question for staff. I accept Senator Deed's suggestion or premise that we do not have law enforcement zones in Virginia. Assume arguendo that to be true. Is there any prohibition, this is to Charles or staff, that would prohibit the General Assembly from passing a law that prohibited the establishment of law enforcement free zones, notwithstanding the fact that there isn't one that exists today?
Charles?
If your question is there anything that would prohibit the General Assembly from making a
prohibition,
position of saying law enforcement free zones are prohibited? No.
Okay. Mr. Chairman?
Senator Morrissey.
If I understand correctly, and Senator Stanley will correct me, does it all the time, all this bill does is say that we are going to prohibit any law enforcement zone in the Commonwealth. That seems to me as reasonable and as practical and as purposeful as breathing oxygen. Why wouldn't we do that? Conversely, if we were to say 6 months ago, even contemplate setting up a law enforcement free zone, every rational person in this Commonwealth would say, are you kidding? Why would we set up an area where where law enforcement could not enter? So I think and I'm grateful that we don't have any law enforcement zones yet, but as staff just told us, that doesn't prevent us from prescribing it. And for that reason, I think I'm certainly going to support the bill, and we can debate this forever, but if it's appropriate, Mr. Chairman, I'd like to move to pass the vote and ask for a vote.
I'd like to ask Senator Stanley a question. How would you define a law enforcement free zone? What are the parameters?
Mr. Chairman,
what would a judge do to describe, to hold that this is a law enforcement free zone? How would you go about proving that?
So, Mr. Chairman, we'd start with the definition in this bill, which starts at line 11 for the purpose of this section. A, that law enforcement free zone means a geographical area, building, or other structure that law enforcement officers are lawfully entitled to access, but are instructed, demanded, or forced not to access, or access only in exceptional circumstances by a person who has the lawful authority to direct that law enforcement agency to act or not to act. And of course, then we have a limitation on that. It does not include geographical areas, buildings, or structures from which the law enforcement officers are briefly not allowed to access as a tactical decision intended to resolve safely and expeditiously a specific and ongoing unlawful incident posing an imminent threat of the safety of the individuals or law enforcement officers. So I think it gives a very specific definition in terms of what is a law enforcement free zone and who creates it. Now remember, the original genesis of a law enforcement free zone is not the public servant, the person who has the lawful authority to direct law enforcement away from the area. It's usually created by the crowd, the protesters, or a mob. And at that point, the second after the origins occur, then the act by that public official to direct people away from that area creates the law enforcement free zone under the definition of this amendment in the nature of a substitute.
Senator Stanley, isn't this something that law enforcement procedures and discipline and authority would have to be involved in exclusively? That is, the chief of police would have to make these decisions, and isn't that something that his boss, the city council, whatever, would have to oversee, or the city manager would have to oversee? Isn't this something that's administrative only, and you wouldn't put it in the law?
I wouldn't put it in the law? Mr. Chairman, I answer your question by saying no.
Mr. Chair.
Any further discussion? Senator Sherrill?
Peterson.
Senator Peterson.
I'd add a question for Senator Stanley. If my teenage daughter locks me out of her room, does that qualify?
Mr. Chairman, I'd answer the gentleman by saying only if the person who can direct the lawful authority to direct law enforcement, which would be his wife, then directed law enforcement to be out of that area near her room.
Any further discussion?
Mr. Chairman.
I'm sorry?
Mr. Chairman, it's Steve.
Yeah, Steve Benjamin. Thank you.
My concern is this. All of the scenarios to which the bill is intended to be directed are understandable. The problem is, and my concern, are the unintended consequences of a bill that could substantially limit the discretion of a police chief. What the bill says fundamentally is that a police chief may not prohibit one of his officers from going into a place or a building that officer otherwise has authority to access. And I'm concerned that in our appreciation for the scenarios the patron intends to prevent, we are not considering the unintended consequences of prohibiting a police chief from appropriately and reasonably directing his officers. An example might be if an officer secures a search warrant to enter a home, then he has the authority to enter that home. But if the police chief finds out that there is something about the circumstances of this search warrant, perhaps it was issued on a totally fraudulent affidavit, and directs that officer not to execute, and wants to direct that officer not to execute that search warrant for entirely appropriate reasons, this prohibits him from doing so. My only caution is that we should be very careful about limiting the discretion of law enforcement supervisors, police chiefs, and sheriffs from directing their men in circumstances that sitting here today we can't possibly envision. The scenarios that are described, easy to understand, but this goes far broader than that, and that's my note of caution.
Mr. Chairman. Mr. Chairman.
Mr. Senator Morrissey.
Thank you. Mr. Benjamin, would you please look at line 17 where it begins, law enforcement free zones does not include and sequential language? Sure. Doesn't that assuage your concern that you just shared with the committee?
No, it doesn't. I looked carefully at that, and that's dealing with a tactical decision to avoid an imminent threat to the safety of an individual or a law enforcement officer. And that's a different situation. I'm concerned because of what we're doing. We are prohibiting a police chief from acting and directing his men And I don't know to what extent, if any, we have heard from the chiefs of police or the sheriff's association. I would feel much more comfortable if we had their insight and their thought, because it's those folks who we are limiting.
Mr. Chairman?
Yes, Senator Morrissey.
Steve, would you look at line 19, and this is the last time I'll ask you this question. Would your concern be assuaged if it now read, being not allowed to access as either a tactical or legal decision?
Or you'd have to change and modify the following language because it still focuses on preventing an imminent threat to others. And a police chief could have a number of reasons for directing his officers not to go somewhere that they are authorized to go beyond a tactical reason or legal reason to deal with an imminent threat. But again, I think the people to ask are the police chiefs and the sheriffs. We just don't know. I've heard this committee talk for many years about the need to yield to the discretion and the judgment and the experience of law enforcement because they know their job and we do not. And so this committee has always been very circumspect and very careful not to tread on law enforcement and to permit them to do their job as they need to do it.
Mr. Chairman, this is Senator Stanley LePage.
Senator Stanley.
Thank you, sir. I spoke with John Jones a while back when we discussed these legislative priority and other ones which were the priorities of the Sheriff's Association. He had no problem with it. This is not aimed at harming police officers or the chiefs or the sheriffs in making decisions about whether they can go into an area safely or not. This is, quite frankly, a bill that prohibits the higher up, the civil authority, from saying, nope, you can't go in there. We're going to pull back our law enforcement. We're going to let that area be law enforcement free. We're going to let that area not have their laws enforced and have mob rule.
Senator Stanley, I have a question.
So this bill is really, do you want chop zones or do you want to prohibit them in Virginia? Do you want to allow them to occur or don't you? It's an up or down question.
Senator Stanley, I have a question.
Mr. Chairman,
Isn't that
easy
why we
fix
have
for
a
that.
democracy, to elect people that have good sense?
Move to report.
Mr. Chairman, we could amend this to do what Senator Stanley has suggested.
Which is
On
what?
line 18, that language could be amended as follows. The establishment of a law enforcement free zone by a person other than a law enforcement officer who has the lawful authority to direct a law enforcement agency is prohibited. Then you're not interfering with police chiefs or sheriffs, and you're prohibiting somebody in the administration from directing the police force not to do something.
Move the amendment.
What's the amendment?
Oh, my God.
Is Steve articulated?
Sure.
Somebody want to make that as an amendment?
Line 18 should read, the establishment of a law enforcement free zone by a person other than a law enforcement officer who has the lawful authority to direct a law enforcement agency is prohibited.
That's my amendment.
Stanley, is that your amendment?
Yes.
Senator
hybrid.
McDougal's amendment, Senator Stanley seconded it. Okay. Any discussion? All in favor of the motion say aye. Aye. All opposed, no. No.
Move to report as amended.
It's been moved and seconded to report as amended. Let me say something. I think this is the most useless piece of legislation I've ever seen. Absolutely useless. It does absolutely nothing. It's strictly a political thing. Somebody doesn't like Seattle. And so, actually, I like Seattle. It has the best salmon anywhere in the country. But that's all this is. It's a political piece of legislation that does absolutely nothing.
John, you haven't seen some of your bills then lately, have you?
No. Okay. It's been moved and seconded. We have a motion to move and and second that the bill is amended be adopted. Any other motions? Okay, all in. Substitute motion by Senator Deeds to PBI the bill, second by Senator Lucas. All right, the motion is to pass the bill by indefinitely. Clerk,
I move the previous
will the clerk call the roll?
Senator Saslaw. Senator Norman. Senator Lucas.
To PBI? Absolutely.
Senator Obenchain. Senator McDougal.
PBI, no.
Senator Stewart. Senator Stanley.
PBI, no.
Senator Chafin. Senator Deeds.
PBI, aye.
Senator Peterson. Senator Servo. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey. Senator Edwards.
Aye.
Eight ayes, 5 nays.
Mr. Chairman, this is Senator Stanley. I will make sure that I'll bring some T-shirts for our committee that says Virginia is for chop zones. All right, thank you.
No, Virginia's for lovers. We know that.
I'm sorry, chap zones.
Okay, no motions to change the motto of Virginia. Now, we have no further bills, I think. Is that correct?
That's correct, Mr. Chairman.
Okay, the motion is the committee will rise and adjourn. Thank you very, very much.